Very good evening to all of you. Because I had committed myself that I would definitely be meeting you, despite the fact that it seems extremely uh, difficult for me in terms of my availability. I managed to be able to get back to you online at this time of the night, just to make sure that we remain consistent to our resolution to be able to have more engagement on daily basis. So let us spend at least 1 hour to do something and then we go out of here. Uh, I propose to exhaust those matters that we set ourselves to do yesterday. That is starting from using some of the questions from the from the previous exams to provide a platform for us to have more uh, revision on random topics. I would say random topics in the sense that the questions themselves are from different areas of the SACE subjects. So therefore, so long as we are, for the time being, using some of them to provide like the basis for our discussion. You'll be jumping from area to area, but that is not going to remain so all the time. But for tonight, that is what we are going to do. Subsequent meetings, we can have like a focused thematic discussion as it were. Okay, so somebody is alerting me that we got to question 13. Okay, so moving on from what we have been discussing, we state the question and then we use the issues which are thrown out as far as the question is concerned and the options to provide some material for some kind of extended revision. So 13, as a rule, willing self-exposure to injury or loss or risk releases from the duty of care, which would normally devolve upon them, provided willingness is genuine. What is this rule called in the law of thought? Okay, so a certain proposition has been stated for us, or certain principle has been stated for us. We are invited to name that doctrine or that proposition as it's well. So I think that is a very straightforward for us. So let's look at the options. Audio otaram partem. Audio otaram partem simply means that hear both sides of a matter. And it is one of the limbs or one of the principles embedded in natural justice. The other one is the nemo iudas in causa sua, which simply means that uh, avoid bias or do not be a judge in your own cause, a matter in which you have an interest. You don't have to preside over it. That is a nemo iudas in causa sua. But all the otaram partem means that hear both sides of the matter before you decide. So certainly, if you look at the proposition stated there, it does not really relate to that. So you rule that out. Caveat emptor rule. Caveat emptor. Sorry, I think the internet is being a bit rough, but we'll manage and see what we can do. So one of those challenges which will not prevent us. Yeah, so we're still looking at the question 13, and I was just commenting on the options in order to method to rule out the wrong answers so that we get to the correct answer. And I've explained audio term pattern. So we go to caveat emptor. Caveat emptor is a simple from the sale of goods, right? From commercial law, from contract, especially sale of goods contracts, that let the buyer beware, of course, and then a number of exceptions are developed there. As you will notice, in the past, they used to have sale of goods or commercial law as part of the examinable areas. But there was one particular year in which they brought a question, and the question itself was somehow fraught with some ambiguity in terms of whether it should be interpreted as a straight question in just a sale of goods, or it should just be looked at as a general law of contract. And I think that that provides part of the reason why in the 6 courses which are examined, they have commercial law or sale of goods as well, for good reason. So caveat emptor is not the option. Voluntary non-fit injury. Yesterday we explained that simply means voluntary assumption of what? Of risk. Voluntary assumption of risk. In other words, where someone owes you a duty of care. However, by your own conduct, when it can be demonstrated that you have voluntarily exposed yourself to injury or exposed yourself to which you know by the nature of the circumstances that you find yourself, there's a rare risk of you know that. And nevertheless, you go ahead and do that. Now that will release the party who was under duty of care to ensure that you don't get injured or you don't suffer that kind of loss. And that is the answer which the question is looking for. So that is why I said that as a rule, willing self-exposure to injury or loss. So willing self-exposure means voluntary assumption of risk. Voluntary assumption of risk. And that is why we say like the voluntary non-fit injurer. And that certainly releases those who owed you a duty of care from the duty imposed upon them by the law. And so long as you are voluntary and voluntary assumption, that is why I said that provided willingness is genuine. In other words, you are very much aware and have freely assumed. Let me give you an example. Let's suppose that someone gives you a lift on a bike, right? And you don't wear helmet. You don't wear helmet, he has a problem, you get injured. Because you did not wear helmet, you have voluntarily assumed risk. So even if he is going to be liable to you at all, so far as you did not put on helmet, meaning that the activity of riding on a motorbike is inherently dangerous, you threw caution to the wind. The person who was in charge of the motorbike will be released from the duty, or what we call the contributory negligence. Contributory negligence in the sense that you ought to have put on like the helmet, which you didn't do, but those will be, what does the person put down there? Okay, so some the question, what is the difference between the contributory negligence and a voluntary non-fit injury? Contributory negligence is where the liability in terms of like negligence has occurred, but we look at the victim. The victim is the person who is at the receiving end of the tort. If the victim, by his conduct, contributed towards the particular injury which he or she has suffered, then the extent of liability which the original tortfeasor will bear is going to be reduced So there will be some sort of like an apportionment of liability, if you like, either having regard to the circumstances, the victim of the tort is going to be made to say that, okay, by your own conduct, you contributed the particular injury or loss. And for that matter, liability of the tortfeasor is reduced by 30% or 40% or whatever, as the case may be. But that will be judged on the merits of a particular case. And the fundamental thing to remember is that by contributory negligence, it's not automatically releasing the tortfeasor from blame in terms of a responsibility for the injury that he has caused. It is only reducing the extent of compensation which you have otherwise have to pay to the victim, because the victim also failed to exercise some reasonable care, and that has, if you like, aggravated or worsened the injury that he has suffered. Yeah, so that is about the contributory negligence. But voluntary non-fit injury, as we said, is where you have willingly, let's use the words of the question, where you have willingly expose yourself to injury or loss or risk. You know that a particular activity or transaction or situation, despite the fact that it's an care of another person, is inherently risky or dangerous, and you decide to undergo it regardless of. And like a typical example, uh, let's suppose that you know that I don't have a license to drive. Okay, you know that I don't have a license to drive, and even on my car, I have written on it that riders or passengers they ride in this car at their own risk, and I've told you, and yet you decide to still join me in the car, knowing very well that I have not been licensed or certified to be competent to be able to drive. Now that is a voluntary assumption of risk. And if, for example, an accident should occur, if the accident should occur, the person, the tortfeasor, that is the person who was driving the car and all that, he can raise the defense of voluntary non-fit injury, that you, the victim, voluntarily assume the risk of traveling in a car driven by someone who known not to be licensed, and there are so many indications, and yet you threw caution into the wind and you decided to ride in it. So that is about that. And then the res ipsa locuto. Res ipsa locuto is a way of discharging evidential burden when it comes to establishing a breach of a duty of care as an element of a tort of negligence. By the res ipsa locuto, you are simply saying that the matter speaks for itself. That, for example, ordinarily speaking, you are not supposed to find a nail, let's say a bottle of beer. So you have your star beer and then there's a nail in it. Now, if, for example, you have suffered maybe some injury or damage, which you think emanates from the nail in the drink or something like that, and you have to sue in a tort of negligence. Now, the law says that you must prove that the manufacturer owed you a duty of care and all that, that is fine. However, if you can raise or you can plead that a nail is not supposed to be part of the content of a beer. So having found a nail in a beer, which is ordinarily sealed and all that, that the fact that the nail is in it is an itself indication of the fact that the person who made the bear have been negligent. And for that matter, you don't need to bring evidence to convince the court that the manufacturer or whoever it may be had actually breached the duty of care imposed upon him or her by the law. And that is why we say res ipsa locuto. That is, res in Latin means the thing. So in Latin we say res rebus, the thing or the matter. So by very fact that you have seen that particular thing in it, you are saying it's an evidence of what? It's an evidence of negligence, an evidence of breach of duty, unless the other person who has control over that particular thing, which ordinary should not have, let's say, a nail in it that can provide some other explanation as to why that is still possible, and it should not be it should not lead to the automatic conclusion that there has been a breach of duty of care. Otherwise, the court will be entitled to infer that there has been like the breach of duty of care. So that is how res ipsa locuto operates. Now this will take us to question 14. The phrase quantum merit literally means that, so when you say quantum merit, your attention should go to where? To law of contract, discharge of contract, especially when we are discussing the rules on the discharge by performance. And remember, discharge by performance. So discharge by performance means that contractual obligations or duties are not considered to have been met unless they have been carried out precisely or exactly as were actually stipulated in the contract. And there's what we call like the precision rule, right? The precision rule of performance. You are very familiar with the case of like the Carter and Powell. Where somebody was supposed to work on a ship, the ship moving from in the Jamaica to Liverpool. In the midstream of the voyage, the person died. And then the wife of the deceased seaman decided to sue for the wages which the deceased seaman had made before his demise. And the court was the view that the obligation in the contract was that he was supposed to work on the ship Jamaica to Liverpool and not part thereof. And for that matter, he has not carried out exactly what the contract said that he should do. So the precision rule of performance had not been met. And for that matter, the contract could not be said to have been discharged by performance. But a number of exceptions exist to the precision rule. And one of those exceptions is what we call the doctrine of substantial performance. The doctrine of substantial performance simply means that where you have obligation under contract and you have carried out significantly the entire obligation, maybe save some minor defects in the performance, then you'll be entitled to payment for the substantial performance, and the court will be applying the quantum merit principle. So quantum merit simply means that as much as your wet is wet, I mean, as much as your performance is wet or your performance deserves. So we will value what you have performed, and then to the extent of your performance, we would let you get part of the agreed contractual price, as it were. So of course, if you are doing a construction contract, the equivalency of a quantum merit is what we call the pro rata, meaning that to the extent of what you have performed, what you have done. So if you look at the question, the phrase quantum merit literally means A, A contract for sale? Obviously, no, based upon the explanation that I've given. What is a contract for sale? It's meaningless, isn't it? B, the fact itself. The fact itself. The fact itself is not quantum merit. The fact itself will be the Latin word, how do you call the epistema verba or factor. That is the fact itself, or by virtue of the fact. So that is not quantum merit. As much as is end, as much as end, as much as end. That is closer to what we have said. As much as end, as much as the performance deserves weight, as much as the performance is weight, that is quantum merit. So as much as end is the most closest meaning, and for that matter, C is the most likely answer. You cannot say that none of the four that we have, at least we can say C is closer to the meaning that we have discussed. Okay, let's look at the 15. Somebody is asking whether res ipsa locutor is akin to strict liability. I wouldn't. If you say strict liability, do you mean strict liability as in criminal law, or strict liability in what sense? I wouldn't like us to just oversimplify res ipsa locutor and say that res ipsa locutor is equal to strict liability. Although I can appreciate the link or the analogy which you are trying to do, that is fine, but it does not necessarily mean that the two are interchangeable. Now let's move on to 15. An agreement for a lease may be enforced under one of the following equitable maxims. As soon as I say agreement for lease, there's a principle called the rule in Walsh and Lonsdale. The rule or the principle in the Walsh and Lonsdale, if you remember that, rule in Walsh versus Lonsdale. It's a very old principle. In your land law, you might have come across it. Walsh and Lonsdale. Let me just type it here for you. Lonsdale. So by an agreement for a lease may be enforced under one of the following equitable maxims. A, equity imposed an intention to fulfill an obligation. Yes, that is a equity, but is that the principle which supports the enforcement of an agreement for a lease? Okay, yes, when you say equity imposed an intention to fulfill an obligation, that is to say that where there are some legal formalities which needs to be done before a certain transaction be considered properly constituted in law. If all those formalities have not, for example, been met. However, there are indications pointing to the fact that that particular transaction, in respect of which the required formalities have not fully been met, is what the party is trying to achieve. Then equity will say that it is the substance which matters, not the form. So equity, yeah, will pay more attention at the substance and not the form. And equity will impute an intention to fulfill an obligation. Or let's suppose that you have an obligation to perform and you have done something which has the effect of meeting that obligation, but you have not actually declared or you have not made it known that what you did was in pursuance of discharging or meeting the obligation. Now, despite the fact that what you have done, you have not expressly declared that it was towards the meeting of this particular obligation, equity will impute, that is, equity will assume that will fix you with the intention that what you did should be taken as an effort by you to meet an obligation that you bear already. So let me give you example. Let's suppose that you're owing someone 10 cedis, right? And the person has not made any demand notice on you or whatever, and you go out of your way, let's say, to dash the person 20 cedis, and you don't even make it clear that what you are doing, part of that 20 cedis you've given is, let's say, towards discharging your debt obligation for the 10 cedis. Now, paying the 10 cedis is an obligation that you owe. And what you have done, despite the fact that you have not explicitly made it known that it is towards the payment of the debt that you owe, equity would impute an intention on your part that the 20 cedis that you paid was also meant to pay the debt of 10 cedis, which you owe the person to whom you had dashed the 20 cedis, as it were. So equity imputes an intention to fulfill what? An obligation. Then equity regards as done that which ought to be done. Equity regards as done that which ought to be done. That is to say that if you have an obligation to be met, and then you have done it, of course, it's also linked to the fact that equity will look at the substance and not the form. And some of these maxims are talking about, I must say that they do not necessarily operate in all or nothing fashion, and some are interlocking or some are interconnected. See, he who comes to equity must come with clean hands. And we are too very familiar with that, that if you are looking for assistance of the court of equity, because equity is based upon good conscience and fairness, then you yourself must not be guilty of the particular wrong for which you are seeking a remedy. So coming to equity with clean hands doesn't mean that you must be saintly or you must be an angel or you must be someone who is righteous. No, that is not the point. We are talking in respect of the particular grievance which you are bringing to the court of equity, that you yourself should not be responsible in any way for the particular wrong, for the particular grievance for which you want the court of equity to intervene. And that is why we are saying that he who comes to equity must come with what? Must come with clean hands. or just as we say in ordinary English, that those who dwell in glass houses must not throw stones, if you like. And then equity looks at the intent rather than the form. Equity looks at the intent rather than the form. So that is another way of talking about what I said. Equity looks at the substance rather than the form. So it's not like the formalities which matters, but the intent, the substance which matters. And this is particularly so when it comes to even like the either will or making a deed of gifts, or even creating a trust, where sometimes straight legal formalities might not have been met squarely, but there are some other indication which clearly show that this is what you intended to effectuate. Then equity will uphold that, despite the fact that there are some formalities which are lacking. So we come back to the question. Agreement for a lease. Agreement for a lease is not the lease itself. So let's get it. You have an agreement for someone, a lease. It is different from like the lease itself. And there's a principle we call like the rule in the Walsh and Lonsley that a contract for a lease is as good as a lease itself. Good. So which of these maxims can support the usual saying or the usual proposition that an agreement for a lease is as good as the lease itself, and for that matter, it should be given effect to? Is it B, equity regards as done which ought to be done? As for C, you can easily cross C out, that C is not part of the possible answer. Equity looks at the intent rather than the form. So there's equity imputes an intent for an obligation. And then the A2 can be crossed out as not being the most likely answer. We are still using the elimination method, don't forget. So the correct answer will have to be juggled between B and what? And D. Equity regard as done, that which ought to be done. Now, there's an agreement for lease. The lease itself has not been constituted or has not been executed. But as we know, under appropriate circumstances, an agreement for lease may be enforceable by specific performance and all that. So therefore, and that is why Walsh and Lonsley will even tell us that an agreement for lease is as good as the lease itself. So equity looks at the intent rather than the form, as opposed to equity regard inputs regard as done, that which ought to be done. Which of these two will you go for as the most likely response? Equity regards as done, which ought to be done. Okay, so Emmanuel Zika, why B? Emmanuel Zika, why B? Yes, you can speak, Emmanuel.
Yeah, Doc.
Yes.
I think if you look at the well, I was just taking considering the rule.
Sorry, Mr. Zika. Oh, I think we've lost him. I think he's not the only one who got that correct answer, but I'm not interested, as I told you, I'm not interested in just the answers. I'm interested in the discussion or the explanation. The reason being that there is no guarantee that they repeat questions they have brought before. But what is important is that if you have the understanding of the relevant areas, whichever you get, you'll be able to reason out the correct answer. And that is my philosophy. So I'm not so much those who would just like to memorize answers to questions without understanding why they have that answer. I want you to understand why you have chosen the correct answer and the other options are wrong. Yeah, that's what I want us to do. Who else? Okay, so Daniel Saki. Daniel, Linda, okay, okay, Linda Na Koko is talking D, and then Elsie is also taking D. So I'm going to hear the D and then the B. So Linda, Na Koko, why D?
Sir, please. So, I realized that I looked into my equity notes, and then under my equity notes, the rule 9, it had the wash versus the Lonsdale, and that's equity looks at the intent rather than the form. So, and then when I was thinking about it, you see, as initially, common law was very rigid and inflexible, and so equity came to being. So, if when someone has maybe when there is an agreement to contract for a lease, the law is saying that initially, common law would not allow for such a lease to be termed as like a proper lease, like just the agreement to be termed as a proper lease. But under equity, such this one, just the agreement is as good as the lease itself. So that's why I think it is D instead of B.
Okay, all right. Thank you very much. Let's take the other people. Daniel. Daniel is gone. I think. Okay, so then another hand. Who is that? Okay, yes. The name is not there, but I've released. We can talk. Salom. Okay, Salom. Yeah, Salom.
Yes, hi. I'd go with B.
You go with B.
Yes,
You are interested
as
in.
opposed to D, because I think that D seems to suggest, looking at the question, which is talking about an agreement for lease being enforced, D seems to suggest a situation where there has been an agreement, or maybe there is a lease, but maybe the way in which the lease has been couched, or maybe the title of the lease or something around that is problematic, as opposed to B, which gives an indication that maybe the agreement for the lease has not actually been put into writing. I don't know if.
Yeah. It's.
Yeah, so I would rather go with B as closer to answering that particular question.
Okay. I think it makes sense. If you look at the page 35, if you look at page 35 of my book, we have like the equity regards as done, which ought to be done. So where a contract is specifically enforceable, equity regards a promisor as having already done what he has promised to do, because he can be compelled to do it. Therefore, as was seen in Lonsdale, a contract to grant a lease is treated as creating an equitable lease on the same terms. Okay, so that is that. So let's move on to 16. In the law of contract, the display of goods in a shop with the price tag on them is called, of course, this one, I'm sure that if you are even sleeping and you woke up, you can just tell us the right answer. So we are not going to belabor it. Display of goods with the price tag on them. Let's go through the options. A, an invitation to tender. Of course, invitation to tender is a different matter. So certainly it's not about display of goods. Invitation to tender is also a form of like an invitation to trade. But that is not what we are talking about here. Because in that respect, you are soliciting a proposal by people who can supply maybe some goods, or who can perform a particular service, and then they'll provide their estimates, and then it is up to you to determine which of them you award the contract to do. That is an invitation to tender, but that is not what the question is actually talking about. So by elimination method, that is out, it's not the answer. B, an invitation to negotiate. An invitation to negotiate. An invitation to negotiate. You see, the answers the examiner give, it could be a bit misleading, because invitation to negotiate is not different from invitation to treat. Because invitation to trade simply means that come forward, make an offer or proposal which may be accepted or rejected. And for that matter, is in substance similar to inviting someone to do what? To negotiate. But because we are in the area of the law of contract, and the usual terminology, which we know, is invitation to trade. So we just have to ignore B as not being the answer, and then move on to look for the usual legal expression. So C, invitation to trade. So where goods are displayed in a shop, the price tag on them. We know the cases of Fisher and Bell, the case of the Pharmaceutical Society of Great Britain. They all support the point that where goods are displayed with the price on them, that constitutes what they call an invitation to treat. Of course, if you go to the US, if we take cases like the Lasky against the grocery economy, it will tell us something different. But at least in terms of our contract law principles, we don't necessarily follow the uniform, the restatement of contract law in the US. We rather follow the common law as inherited from Great Britain, and also developed by our court. The case of NTHC versus Entry, for example, will reinforce some of these explanations. Then an offer to buy the goods. No, it's not an offer to buy the goods. Because if it says an offer to buy the goods, then you are trying to bring the ratio in the Lasky against the grocery economy, which is a US position and not the English position. It's also not the Ghanaian position. Some of you have, let me look at how to put over there. Okay, so okay, that is fine. We have a few minutes when let's move on. At exactly 11 we will end. Number 617, where a contractual clause provides for the payment of a sum in the event of a breach, which is a genuine pre-estimate of the potential loss to the innocent party. Such a sum is called, so this is a very interesting area. So it has to do with the remedies for breach of contract. I think we have discussed that, in on one of our previous sessions, remedies for breach of contract. So we talk about damages. You've explained damages as the monetary compensation, and the aim of awarding damages is to place the innocent party in a position that he or she will have been had the contract be performed as far as money can do. and not to punish. So it's not punitive. And we have noted that damages, we have liquidated damages as opposed to unliquidated damages. Liquidated damages simply means that the parties have attempted to estimate how much loss may be occasioned to an innocent party should there be a breach of contract. And they have made provision in terms of how much money should be paid for that. And that is the liquidated damage clause. And that is consistent with the aim of awarding damages as stated in the case of Robinson and Harman and so many cases, that is not to punish, but to put the innocent party in the position that he or she have been performed. And you remember the case of the Dunlop pneumatic tire against Selfridge, where Lord Daniel enunciated the principles that enable us to determine whether an amount of money which have been stipulated in a contract as amount to be paid in the event of a breach can be classified as a liquidated damage clause or a penalty clause. And he made the point that where the amount of money stated is exorbitant, in other words, is quite excessive, having regard to the maximum loss that may be occasioned or suffered in the event of a breach, then you cannot say that that is a genuine pre-estimate, and that will make it a penalty and not a liquidated damage clause. Or where the same amount of money is supposed to be for different types of breaches, that also raises the suspicion that that is not a genuine estimate, pre-estimate of the loss. Because how can you say that the same amount should be paid for all manner of breaches when the breaches may not be the same? Some may be more severe, some may just be quite minimal. So that will also make it the penalty clause. So let's come back to the options. Where contractual clause provides for payment of a sum of money in the event of a breach, which is a genuine pre-estimate of the potential loss of the innocent party. Such a sum is called A. Unliquidated damages. No, that is wrong, because unliquidated damages simply means that the court will have to carry out the assessment and determine the quantum of damages and the entitlement of damages, as it were. So that is unliquidated. Liquidated damages, yes, that is where the parties have made like a genuine pre-estimate. So that is what the question is looking for as the answer. Liquidated damages. Penalty for breach, no, that is not a penalty because of the emphasis on the genuine pre-estimate. And then exemplary damages, no. In law of contracts, we don't award exemplary damages because exemplary damages are supposed to be punitive. So law of contract, we don't award exemplary damages. I think that I will take questions and then we end because I'm tired. I've done a lot of teaching from morning to now in my university. So let me take a few questions and then we will end the class for tonight. So if you want to ask a question, just raise up your hand. The next 6 minutes so that at 11 we can close. And then we continue to move. Let me see. Are there some hands up? Okay, so we have Francis. Francis hand is up. Yes, Francis, you are released.
Yes, sir. Good evening, sir.
Good evening, Francis.
Sir, I'm a bit confused about question 17, the very last one you have just resolved for us. The actual or accurate expression we've learned from the previous lesson, as from our faculty laws, is liquidated damages, not liquidate damages.
So I think that is a mistake. It's a typo. You know, these things were typed. So it's a typographical error. It's not. I don't think it was in the original question. And it's liquidated. It's not liquidates.
So it means that probably there is no right answer in this.
The liquidates in B is wrong. I'm sure it's a typographical error. It's supposed to be liquidated. Okay.
Yes, sir. So what I want to learn from you now is that should we meet such a situation, do we just choose something like B, which is also not the actual expression, or do we take it that there's no right answer there?
All that I'm trying to say is that on this occasion, the liquidates that you saw in B is a typographical error from my end, not from, I think, the question paper. I don't think so. I don't know if you get my point. And it is not likely that at this stage, any examiner will write liquidate damages unless the person is looking for something else. I think somebody is asking for distinction between is it general damages and unliquidated damages? No. Okay, usually we draw the distinction between general damages as opposed to special damages. And then we draw the distinction between unliquidated damages and liquidated damages, as well as a penalty clause. So general damages, that is like the principle in Headley and Basender, that when a breach of contract you can recover compensation losses that arise naturally from the breach of that contract. So those are the general damages. And special damages refers to those losses which you can recover compensation, provided you gave information to the other party, which made the other party aware that in the event of he defaulting, you are likely to suffer those losses as well. So where that is the case, then you can recover compensation. We call that the special damages. And as we saw in the case of a Victoria Laundry, yeah, we'll just be ending soon. I think the line went off. Yeah, so I think that those are the kind of distinctions which are made out there. Yeah, so I think that's the question. I think we have exhausted your questions. Okay, somebody is asking, Jacob is asking that what about substantial performance? Is it at the discretion of the court or a party can claim it? The substantial performance is an exception to the precision rule of discharge of contract by performance. You know, by the discharge of contract, by performance, there is this principle that you cannot be said to have been released from your contractual obligation unless you have carried out strictly and exactly what the contract said you should do. And that is why you look at some of the old cases that if the contract said you should supply, let's say that 100 tins of, let's say, sardine for it to be packed, let's say 20 in a row and all that. And if you even supply the 100, but you didn't pack it according to as was agreed, but you still supply the 100, precision rule will say that you have not carried out what the contract said you should do. So you have not actually performed. But that is quite harsh. That is why exception like substantial performance, that if you have effectively carried out everything, then you should be entitled to the contractual price minus amount of money needed to rectify the defect in your performance or to make up for the shortfall in your performance. So that is how substantial performance operates. And on that note, I would like to say a good night to you, and God willing, tomorrow we will meet again. So have a good night.